First, I'd like to thank all the members of media for attending our event, our meet and greet event this morning. This is the first time that our Chief Justice will be talking to you, the members of the media, and we appreciate it. The Chief Justice knows the importance of media in informing the public of the important decisions of the Supreme Court, and you play a crucial role in the administration of justice. So without further ado, again, I would like to pass on the mic to the 26th Chief Justice of the Philippines, Judicial M. Peralta.
Thank you, Attorney Saka. I prepared a short remark. Then probably you can base your questions on the simple remark. I had called for the President to allow us to get to know each other better in a less formal environment. I decided to retain our PIO chief and spokesperson, Attorney Brian Osaka, not only because he's equally good looking, but because I believe that he has been instrumental in protecting the Supreme Court in a new light. And that being said, allow me to acknowledge you, the members of the Justice and Court Reporters Association, or JUCRA, and Justice Reporters Organization, or JURO, for your continued support in getting our messages across. Your keen sense of duty and fairness is a trait we as magistrates share. Our mandate comes directly from the Constitution, as yours is a manifestation of the liberties granted by it. Those of you who were able to join us last week during my first flag ceremony, since becoming Chief Justice, got to hear about my 10-point program. I will spare you the rather lengthy enumeration today, but will narrow it down to 4 core areas from which the 10-point program took its work. First is efficiency. One of the greatest challenges of the court is its mammoth docket. As of December 2018, there are 8,852 pending cases with the Supreme Court, 19,732 cases with the Court of Appeals, 5,237 cases with the Sandigan Bayan, 1,353 cases with the Court of Tax Appeals, 182,000. That's more than half of a million cases with the regional trial courts, and 160,153 cases with the first level courts. Thus, the elimination of this backlog of cases is my highest priority. Our approach will be to make periodic inventory of cases and engage the court and bank to see what is choking up the system. The other approach is to have a clear monitoring of the court's performance, especially in observance of reglementary and prescribed periods to resolve cases, not only to ensure that our constitutional obligations and duties are performed, but also as a means to recognize and reward those who elevate the quality of justice in the country. Also relevant to efficiency is the continued push for the automation of court processes, the incorporation of court technology in hearings and trials. We have to harness modern-day conveniences to enhance the way we serve our purpose. This will also necessitate the strengthening of the management information systems of the court. Second is integrity. I would like to continue the weeding out of mysteries from the judiciary and push it even further by adopting a system where the court itself may initiate the investigation of cases. It is high time that we take seriously stance against those who sully the court's good name in office. This will also entail the strengthening of the Office of the Court Administrator and implementation of the Judicial Integrity Board, which the Court and Bank has already approved. The idea is to forge a synergy between the functions of these offices through judicial audits, information gathering, and sharing. Third is security. There is a growing concern that there seems to be a rise in incidences of violence against sports personnel all over the country. The evidence nation is obviously to silence, against, intimidate others, and to submit the judicial system to lawlessness. We cannot let this happen. This calls for the strengthening and improving the security protocols of our justices, judges, and the halls of justice. We are confident that we can devise a system, either through legislation or the court's behest, the creation of a security system pattern after the United States Marshals. And fourth, service. Communication and being thrust forward in the smartphone-driven culture we all know. The need for access and quicker response time are a must for any organization. We have to have a channel of communication to the public to serve. I'm interested in setting up a 24/7 help desk in the office of the Chief Justice and other offices to receive concerns of court users. We should be able to directly communicate with them and be responsive to their inquiries. Another area is the need to improve the procurement and bidding processes for faster and more timely implementation of projects. Sometimes urgency takes the backseat to bureaucracy, and we need to address this. I would also see the creation of a strategic planning and management unit under the Program Management Office of the Supreme Court. This will ensure the organized planning, implementation, monitoring, evaluation of court initiatives. Its long-term objective is to guarantee the continuity of these projects to withstand changes in management and leadership. A good case in point is the clinical legal education program started by my predecessor and my good friend, the Chief Justice Peralta. This helps not only the underprivileged for seekers, but also affords qualified law students the opportunity for experimental learning. This sounds like a lot, but I assure you, this is just the beginning and may still grow in number. I am sure you have already heard that I do conduct an unannounced visit to our courts and offices. This is not meant to micromanage their affairs, but to remind them of their accountability to the office they serve. It would not make sense to have a few backlog of cases, complain about the process, yet feel free and remorseless about coming to work at 11:30 in the morning. I am not a workaholic, but I love to work. I work hard, and I am reminded by the thought that I do my job and well. I hope that does not make me sound self-righteous, but I am just a stickler for rules. I don't expect everyone to wake up at 4 a.m., job, have breakfast, then head to work. Not everyone is a morning person, but we all have jobs to do, and we owe it to the people we serve to do our best. Again, I thank you. I hope that you continue to support the Supreme Court and help us bring the bells of justice loudly and clearly. Thank you. Ryan?
Okay, we open the floor now to questions if you would want to ask the Chief Justice. Can you use the microphone so we can hear clearly?
I would rather leave it to the young people to ask the questions.
Hi sir, I think just a few days ago, Judge Jocelyn solicited his request to Supreme Court for a 30-day extension to resolve the Manila massacre. And he also reminded the lower courts to strictly comply with the prescribed periods to resolve any cases among others. How will the court go about it?
Under the Constitution, it provides that all trial courts, that means the first level and second level courts, should promulgate their decision within the 90-day period. But there are some rules that require a short period to promulgate the decision. In the case of the Judge Judicial, you know very well that there are so many accused and there are so many victims in that case. Yeah, but we also allow meritorious motion for extension, and we understand our predicament. and we allow her to have an extension of 1 month. But as I said, motions for extension, the exception rather than the rule. So we understand her side, and I hope that she will no longer ask for another extension, so that before the end of the year, that those cases will be finally decided.
Okay. Sir, still on the naman. Sir, are you disappointed that this case has dragged for a decade?
No, yeah. You know, I was a fiscal and I was a judge. This is my first time to hear cases involving so many victims. I think in the last century, I have yet to hear cases involving massacre of so many people. And you know, the accused are all invited to what we call the process. But we adopted several ways in order to fast track the resolution of cases. It's good that the parties agree to these tools that were adopted by Judge Jocelyn in order to, as early as possible, resolve the cases. So I'm frustrated of what happened to the victims, but I think Jocelyn did her best in order to give justice to the victims and also in order to afford the accused the required due process under the Constitution. Next question.
So, concerning your program, hi sir, good morning. So, concerning your program to get rid of the so-called hoodluming rules, sir, your plans are pertaining to the alleged narco charges.
Now, I don't know if you have heard about the judicial integrity work. Have you heard about it? Yeah, have you heard about it? The Office of the Court Administrator has been doing its best in order to support the ruling of the justice. And we are aware that we have been disciplining judges now. But we have to have an office that will help the Office of the Court Administrator because they have only few judicial officers or the lawyers to go around the Philippines and auditing the performance of our judges. They have only 11 lawyers going around the Philippines conducting judicial audits on our judges. So we thought then that there must be another body that would help the OFA or the Office of the Court Administration. And that's what we are now about to implement. This is the judicial integrity board. We expect that this board will perform its task very well, and we hope that this board will be independent. To those who are still with us and who are not supposed to be there.
It was in April that there was a report that allegedly 13 narco judges included in the narco list of the president. Maybe know that, so what's the update na po on that road, sir?
Well, there are questions that I'm not supposed to answer. I'm sorry, because that's purely confidential. We are investigating them, and I think there are already recommendations submitted to the court and bank, and in due time we will be coming up with some resolutions on these alleged narco charges.
Good morning again. Can you share with us the latest on the Marcos Robredo case?
I think you're aware that there was a resolution of the court signed by Justice Peralta that we require the parties to comment on the pending motion. So we did not dismiss the protest yet. Instead, we gave the findings of the debt on the contested proceedings in the three parties. And we also required the other parties likewise to comment on the motion on the third course of action as to whether or not it will be fair to continue with the third course of action that Bongo Marcos alleged in the protest. Now lately, there was a motion by both parties to photocopy some of the documents that they need, to be incorporated in the respective comments. So the latest therefore that we granted the motion to photocopy all these documents that they need. But after photocopying all these documents, they will now submit their comment within 20-day period from the time that they finish the photocopy of the document. So that's not the status of the case. Of course, of course.
So, sir, is there more or less a time frame on this one? Because, you know, it has dragged for like more than 3 years. So is there more or less a time frame, at least in your incumbency?
Oh, okay, I cannot exactly tell, no, the period it needs to be finished, because it will depend on the comments that will be submitted by both parties, no, regarding their comments on the result, on the protest, and also on the third cause of action filed by Bongbong Marcos.
Thank you, sir.
Welcome.
So, good morning. Sir, the flag has submitted a manifestation. This is regarding the war on drugs case.
What's the manifestation?
They are informing the court about the report, that the copy that they have received, and the report said that the police have copy-pasted the copy-paste reports of all the victims, sir. Has the Supreme Court already acted on this? Like, have they asked the PNP to comment?
What I can remember with that case is assigned to a justice who has just retired, no? So probably that manifestation or motion that has not yet been acted upon, probably, because I cannot recall of any resolution on the flag petition, no? Of any resolution that we promulgated. But I will check our records. But that case has not yet been terminated, I think, so it's still an active case.
Is it okay? Nobody's asking. Can I just make a follow-up on that? Because there was a motion. I understand that copies should be given to the petitioners of the actual reports of the PNP. Can that be released to us?
Oh, not yet, because we have not yet gone over. I think you're referring to the order of the Supreme Court.
Yes, sir.
Requiring the PNP, the respondents, to submit the list
Yes.
of those alleged cases of
Yes.
EJK. And it was through the Office of the Solicitor General,
Yes.
because that's the lawyer that submitted the list. So that's the latest. So I think we have not yet acted upon on that list. No?
But would you be,
I think it's premature to release it because we have not ruled on it. So let's wait for the court to rule on it, and then probably you can request later on, and let us see what will be the action of the court. But in the meantime, that will be premature. Okay?
thank you again.
CJ, sa Mama Sapano case po, in September, the Supreme Court ruled that there's no probable cause to charge Aquino, Purisima, and Napeñas of reckless imprudence resulting in homicide. With this ruling, can the Ombudsman still reinvestigate, because the VACC will file a motion for reinvestigation this morning?
You know, that might be sub judice, but what I can discuss is what we did with that case. Because there was a motion to withdraw the information filed before the Sandigan Bayan, and you know that it was a motion filed by the Ombudsman. I do not know what's the, the reason why the Ombudsman filed that motion to withdraw. In other words, what will happen now with the case that was brought to us? It involved the same case, so the information was already withdrawn. Then what will happen with our case? Then the case will become moot and academic. So we have also to dismiss the case, because there's nothing more to rule upon, because the very information that was filed in the Ombudsman was already withdrawn by the Ombudsman. I'm not aware of that motion or a motion for investigation filed by the FAC. I think that was filed by the Ombudsman. Let Ombudsman Martires rule on that. Oh, pwede. Basta ikaw.
Sir, yung winidraw po kasi na information ni Ombudsman Martires is an information for graft and usurpation of authority. What the Supreme Court ruled on was the reckless imprudence, and you said there's no probable cause. So,
Yeah.
pwede pa bang i-reinvestigate yung reckless imprudence?
It's like this kasi eh. The determination of probable cause is a role given to the lower court. In other words, it is an exclusive duty of the court where the case is filed what will determine the existence of probable cause in order to issue a warrant of arrest or to issue a commitment order if the accused has been arrested. No. So if you bring that case to the Supreme Court, sometimes, most of the time, we are careful because we do not want to encroach at the very power of the lower court to determine the existence of a probable cause. We might not be in a position because what we only rule upon, especially under Rule 65, is to determine if there is grave abuse of discretion. That's what we said in our ruling. Thank you.
Sir, good morning po. Question po. With regards to the pet case po ni former Senator Marcos and Vice President Robredo po. Sir, alam po ng publiko, alam ng mga tao na you have some decisions na pinalabas favoring, for example, the Hills burial po for Marcos and among other decisions po granting or favoring sa Marcos family. How can you assure po as the Supreme Court sitting as pet, how can you assure po sir na magiging fair ang Supreme Court as far as the electoral protest po between Marcos and Robredo is concerned po?
That's a loaded question, and I appreciate that question. It's
Thank
not
you,
correct.
sir.
It's not correct that I've been favoring the Marcoses. This is the only decision that I favor the Marcoses. It's only in the burial. In fact, my wife, who handled the cases of the ill-gotten wealth when he was the Assistant Solicitor General, she was the one who handled that case against the Marcoses, and she won that case against the Marcoses, and they're aware of that. Now, insofar as the other cases, so you're referring now, insofar as the pet case, I've been always objective in the performance of my work. I always rely on the evidence submitted and the law applicable. Now, in the case of the burial, there is no law or even a resolution prohibiting the burial of a former president. So, what can we do? What shall we do? We cannot resolve cases based on public opinion because we base our decision on the evidence, the facts, and the law applicable. Now, if you ask me what will I do, as the Chief Justice on the petition, then I will, as I said, I will always decide the case, although I'm not the ponente, based on the evidence and the law applicable. And you are assured of that.
Hi, sir. Question, Lian. As far as you're concerned, sir, as far as you know of the circumstances of that case with the San Vigan Bayan, do you feel that there's still a chance that a fresh indictment may be filed against those involved? Against those initially charged and then after the charges were withdrawn?
I cannot predict. That could be speculated. Then I will answer that case. If that case might be brought to us later on. So, excuse me, probably I cannot answer now the question. For all you know, they might not file the case. So, it's really speculative. No? Okay. Thank you. Once in a while, in your programs. Gusto niyo ba? But you have to take care of the bill. Yes,
Chief,
yes.
maybe get more details about your plan to increase security for judges. How will this look like?
It's like this, it's good that my answer might be a little bit long, but I have to explain you this to the public. The Supreme Court may be authorized to create or to employ security services. But the problem in the past that there have been no positive result on the outcome of investigation pertaining to the killing of judges. There are so many cases involving killing of judges, and until now, no case has yet been filed against those perpetrators. Problem with our own security, the only thing that they can do is to escort the judge. That's all. But if the Congress is willing to help us, probably they can come out with a law where the powers that are given to investigative bodies like NBI and the police may be given to us. For example, if like Judge Banyes, no, we just rely on the policemen, no, but we have a marshal. We pattern it after the marshals in the United States of America. Our marshal can do the work. In other words, they can investigate. They can summon witnesses to appear in the investigation. They can likewise ask the different agencies to help us, give us expert witnesses, submit to forensic chemists, and prepare our own investigation. Allow them also to file the cases before the fiscal office. In that way, at least we have control of our marshals, and we can get positive results because they are now under us, and they have also powers similar to the powers of those agents in the NBI and also in the PNP. That's why we are looking for a possibility that the law will be created. Law will be given to us, creating marshals, giving the same powers as to those being given to investigative agencies. Kasi kung kami lang, wala eh. Ayun, marami kaming budget. Mayroon kaming bodyguard dyan. Pag lumapit yan, he cannot arrest. Or somebody is creating trouble in the hall of justice. What does the guard there do? He will summon the policeman. When the policemen arrive, may patayan na, may violence na. But in this case, if we give powers to all these marshals, there is no need to go to policemen. They themselves. So that's what we are envisioning, and we hope that the Congress will help us on this. Para naman matakot ang tao because they are now harming our judges, not only fiscals or witnesses, but judges na eh.
Chief, on your other plan to conduct motu proprio investigations on judges, there have been calls recently, first against the judge who issued search warrants for several activists, people asking for investigation, and General Parlade, on the other hand, asking for investigation on judges who dismiss cases against activists. Unfortunately, one of those judges who have been who dismissed a case against activists is the slain Judge Banyes. On these two items, Justice, how would you address these calls for investigation?
There is no yet formal complaint against the judges because the procedure is there must be a formal complaint. That's the procedure. But in my program, we might resurrect some of the things that justices did before. No, I think Ray is familiar with this, the principle of res obsa loquitur, where even if there is no complaint, if we believe that a judge rendered a decision, come out with a resolution, misapprehended the facts, misapplied the law, and then later on favored a party, if we can see from this resolution decision, then we can initiate the filing of cases or initiate the investigation of these judges. Now, insofar as you are referring to the judge in Quezon City, we have not yet received any report, but from what we have gathered, she followed all the rules under the rules that we have promulgated. She is authorized to issue search warrant even outside territorial jurisdiction. She conducted hearing to determine the existence of probable cause. She conducted the required searching questions, extensive questions, and when she was satisfied with the existence of probable cause, she issued the search warrant. And the search warrant was served. And she required the searching policemen or military men to report to the court within 10 days from the service, within 10 days from the seat of the, and she followed. So can we now take the initiative to investigate her? There's no basis. But if there will be a complaint and there is a basis of the complaint, rest assured that we will refer this to the Office of the Court Administrator for investigation. I think you had another question about a search warrant that was issued by somebody and then he was killed. I think
Judge Banyas was
Judge-
who he acquitted.
Just Banyas, it has nothing to do with search warrant. Based from the papers, he acquitted a drug lord and that he received death threats because of drugs.
So drug related.
Yeah, that's what we heard. The other angle is about, I think there's a question that about a
Missile of the case.
Yeah,
The
and there
acquittal
was somebody
of
acquitted,
an activist.
I think that's not what they are now investigating. It's more on the drugs. There are two cases. One was convicted. The other one is about to be terminated, also a drug lord. So they're concentrating on the investigation on these two cases,
Two drug cases.
the drug cases.
Thank you, sir.
No?
Follow-up lang, Chief, sa search warrants. Sir, how would you respond to the calls of some groups to review the circular that empowers the executive judges of Manila and QC to issue search warrants outside of their jurisdictions?
Alam mo yung that I remember when I was a judge. I think it was during the time. Probably I do not know if Sire history ito eh. I did not. It started with the Ferdinand Court or the Narbasa Court. Oh, the Predwis Castro pa yun. Hindi pa kami abogado. Tingnan mo, hindi pa kayo inipanganak noon, 1978 eh. Alam niya eh. So it's like this eh, You know, the issuance of a search warrant should be done confidentially yan eh. It cannot be done openly. That's why when you apply for a search warrant, the judge will conduct the hearing inside his or her chamber eh, so that nobody will hear. Now, if you apply for a search warrant in the area where the house or the building is located, the possibility of leakage is very high. So by the time that you issue the search warrant, pagdating mo na dun sa lugar, wala na yung tao, wala na lahat. So they envision the system, no? They adopted the system where to avoid leakages, they authorize the judges in Manila, in Quezon City, to issue search warrants nationwide, even outside their territorial jurisdiction. And during my time, so I was one of those who was authorized to issue search warrants during my time as a judge. In fact, you know, we had to congratulate all these judges because if you have seen or you have attended a hearing of a search warrant, it will take a lot of time. Mga at least 2 hours yan, naghihiring yan. Because he has to be convinced of the existence of probable cause. And you can just imagine the search warrants that they issued, or the search warrant or application for search warrants that they received. Marami yan, search warrant that they received. And these are the only two authorized judges to issue search warrant to be enforced nationwide.
Sir,
Yes, ma'am.
Yeah.
Sino pa siya?
your track record show that you have the most drug cases, convictions. What is your opinion on Vice President Lenny as co-chair of ICAD? When the rules of ICAD doesn't say na merong co-chair, will it pose a problem in her actions as drug czar, like later on, or in...
Yung drug conviction ba yan nung judge ako o dito na Supreme?
Sir, ang dami mong conviction, sir. Congratulations on that.
Dito sa Supreme Court?
No, sir.
No.
In your career.
When I was a judge and even a fiscal, yes, I admit there were so many convictions that I rendered.
Yes,
But
sir.
the only one decision was reversed by the Supreme Court.
Wow.
All of my decisions were sustained by the Supreme Court. Oh, there are many popular cases. You can just see
Yes.
them in the National Penitentiary. A lot of them, no, with short names. There was a. In fact, because you asked that question, I remember of a station, one police station in Quezon City, and that was headed by a certain Obilia, Colonel Obilia, where they convicted more than 10 police officers for releasing a Chinese drug lord in exchange for money, and the Cebu confiscated by them was never surrendered. In other words,
I am in Jakarta.
so I convicted them for the crime of qualified bribery, and that is the only conviction since then of a crime of qualified bribery. You can see that in this.
Yeah.
Now,
And
insofar as cases that I decided in the Supreme Court, we are now a little bit cautious because of what they did with the amendment of the law on drugs, especially Section 219165, where there are many things that should be done, no, before you can consider the evidence admissible. Marami na yan eh. And one of the problems why fiscals could not comply with Section 21 is the absence of a media. Because the requirement now is that in drug operations, a barangay official should be present and a media or a representative from DOJ. But you know, when we deliberate on some of the cases, the number one problem of police officers is very hard to look for a media. And where are they? They are already. And where are the members of the media? They are in the Supreme Court or in the DOJ. Now, that's really a problem that we are. That's not the problem. The old law easier to convict eh. Ngayon, very hard now because of those requirements under Section 21, 9165. Yeah.
Sir, the
That's a good
ICAD.
question, huh?
Sir, the ICAD.
The
ICAD thing, the Vice President Lenny being the co-chair, when in its rules there's really no co-chair, will it pose a problem?
I think I cannot answer your question. Yeah. Sorry, ah.
Opinion lang, sir.
Sorry.
I mean, your opinion.
Sorry. Medyo hirap tanongin, baka mamaya sisihin ha.
Okay.
Sorry ah.
Thank you,
You ask
sir.
me another question in confidence ah.
I'll see you in a while.
Sir, follow-up lang po ulit dun sa search warrant. Sir, you said kanina na yung Quezon City judge, there is no, a complaint should be filed before the Supreme Court can investigate. Sir, what about the judges na nag-dismiss naman ng application for search warrant kasi si General Parlade wants the Supreme Court to conduct an investigation against these judges?
We have not yet received any complaint from, it's like this kasi so that you will understand how we entertain cases. If there is a complaint and the remedy is judicial in character, we do not entertain the complaint. For example, you file a complaint against the judge because you're not satisfied, and then you allege some wrongdoings, If based from the resolutions or from the records, the remedy is to go to the appellate court and then question the actions of the judge. That cannot be the basis of an administrative complaint. So there are two remedies. If the basis of the complaint can be cured by judicial remedy, then we have to dismiss that. But if there are allegations of wrongdoings, or misapplication of the rules, and then you file a complaint, then we will refer that for further investigation. It's not always that there is a complaint, i-refer namin dun eh. We have to determine what's the remedy. For example, you claim that this judge gravely abused his discretion in issuing the search warrant. If we look at the records, there is no grave abuse of discretion, there is no gross ignorance of the law, we will not anymore proceed to a further investigation. We will just rule the remedy of the complainant is judicial. So what she should do is to go to the court and then later on question the issuance of the search warrant or file a motion to quash the search warrant before the judge that issued. Pwede naman yun eh. If you're not satisfied with Judge Villavert, file a motion to quash before her court. Or file the motion to quash before the court where the cases are filed. Eh. That's judicial eh. Okay?
So sir, hindi siya motu proprio pa sa Supreme Court. Walang ganun.
No. That's what I'm saying is that if based on the records, alam ni Ray yan eh. Alam ni Ray yan eh. Kasi panahon niya yan eh. Ang ginagawa ng Supreme Court noon, if there is a decision, if there is a decision, makikita sa decision that he favored one party, and then misapplied or misapprehended the facts, misapplied the law, and then resolved the case in favor of a party, when in fact he should have lost in the case, o kung hindi, pinailan ng inhibition, ayaw mag-inhibit, then later on, ang ginawa niya, i-favor the other party, nandun lahat ng evidence, that's the time that even if there's no complainant, we can refer that judge for further investigation or for investigation. That's what I mean, no?
Sir, pwede ba yun may time lang yung search warrant? Like, should be office hours lang? Meron bang ganun?
It will depend on the necessity kasi eh. Court, offices close at 4:30, di ba? If there is an application for search warrant at 4 o'clock in the afternoon, then you have to accept it and then proceed it.
Like if it's a house or barangay hall?
You're referring to implementation?
Yes, sir.
Yeah.
Implementation. Thank you, sir.
Yeah. It will depend on the circumstances eh.
No, parang the order kasi said like the implementation of the search warrant should only be like from 8 o'clock to like 5 o'clock in the daytime lang. After that, hindi na pwedeng mag-implement.
Ngayon na order?
Meron,
Mga
sir.
judges? Meron bang ganun?
I can get it and I'll see you.
Okay, sige.
Yes, sir.
Can we
Yeah.
give chance the others to ask the questions? Who's gonna be next? Okay.
Sir, good morning. Sir, follow-up ko na sa may U.S. Marshal. Sir, since you said it has to be backed up by a law, have you talked to any senator or congressman or baka they have expressed interest in siguro sponsoring po para makreate na po yung bill po? Thank you.
Alam mo, yun ang predicament ng justices ng Supreme Court eh. When we suggest to the Congress and Senate, we cannot, I myself cannot go there and then convince them eh. Or appear in a public hearing eh. Because that bill will become a law. That law might be questioned later on before the Supreme Court. And you have to inhibit. So what we usually do is to make use of another handsome court administrator. The longest serving court administrator. For reasons only he can answer. Why he has been here for a long, long time. No. So what we do is that we discuss among ourselves, and then if there is really any, then we allow the court administrator to go to the Congress and let him ventilate or argue the position of his position. Well, he has been talking with a lot of congressmen. Amiable naman siya kasi. He has been talking a lot of congressmen and senators. And I think after the death of Congressman, yes, we have been receiving receiving encouragement eh. Na bakit hindi pa kayo kasi magkakaroon ng marshal? Sabi nila. So no, I think you place that in the report eh. Kasi that's my agenda eh. Yan ang isang agenda ko. Then what happened? And then it was reported. Hindi ko alam sa Rappler ata eh. Di ba? Hindi, pati si Lian eh. I read also. I think in most of the papers and in the radio and television, and then, you are supporting us for the creation of a marshal. You do not want the handsome people of the Supreme Court and the judiciary eh. Vanish eh. I think to Justice Maidat, because he's our liaison eh. Siya naglalayas dyan. Hindi layas ha. They know our problem eh. Kasi sabi namin, tapos na tayo, dumating na si Jomar Canlas eh.
Hi, sir.
Yes.
Sir, on a lighter note, how do you feel po about some lawyers na hindi po sila nag-behave accordingly on social media? Mga nagmumura on social media, nagmumura ng mga reporters. For example, the country's top diplomat. How do you feel about it po, sir?
Hindi ko binabasa. I do not.
I mean, are you not affected?
Ang binabasa ko lang yung mga reports nyo eh.
I mean, sir, hindi po ba apektado yung Supreme Court na mayroon tayong ganitong klaseng mga lawyers? For example, Gadon, and the country's top diplomat.
Siyempre affected yan, but what can we do? Diba? Freedom eh. Let them enjoy their freedom as long as it does not amount to a crime. We cannot do anything. You know?
Pero could this be a ground for them para ma-disbar?
Meron naman pending cases eh.
Sir,
I will not mention the name.
The DFA Secretary, meron pong pending case?
Ano?
The DFA Secretary, sir?
Wala yun.
Okay, ganito na lang, sir. Just a piece of advice po. A piece of advice to them, to these people. Yes, sir. Being the Chief Justice po.
Mahirap mag-advise, baka they will not follow it.
Why not, sir?
Wala akong authority over them eh. If they will let follow, di sasakit ng ang loob ko. Pabayaan mo na lang sila. Basta sa akin, di ko binabasa. Ang parati ko nang tinitingnan sa bahay, misis ko lang eh.
How sweet po. Thank you, sir. Sir, doon sa marshals ulit. Pwede, sir, konting details, yung rough idea ng what is going to be, how many are they? 1:1 ba yung magiging or upon request? Parang ganun. And will it be part of the PNP or will personnel be taken from the PNP or what?
Kasi ganito, we have around 2,600 courts in the Philippines, and increasing yan. So probably 200 not sufficient. So the ideal number would be probably 500, no? Alam mo doon sa Amerika, when we went there for a educational tour, may inggit ka eh. Yung mga marshals doon, they have their own office, sila nagbabantay ng mga sila nag-check ng mga baril going inside the courtroom. They are in their suits, and intelligent people, bright people. Deterrent talaga eh. Nobody will attempt to go inside the courtroom pag nakikita sila eh. And these are veterans from Iraq War and Kuwait War because they're allowed to retire at an early age eh. Veteran talaga dun eh. Dito sa atin, ito security ko. Dito lang yan. Hindi ba? But of course, college graduate yan. But wala naman siyang authority to arrest eh. Citizen's arrest, pwede. But kung citizen's arrest, lalaban pa yun. But if you see somebody else with a gun, then about to handcuff you, medyo takot ka. Ito, kung handcuffin na doon, baka siya pang bubugbuin eh. In other words, we want that marshals or security to us na meron power naman, duties, meron naman power, meron siyang, he can require parties or witnesses to appear. Parang, should that the case will no longer be referred to the NBI. Kami na mismo mag-imbestiga, then give them the power to file cases before the fiscal's office. Parang ganun sana, but of course, as I said, there's a need to have a law creating marshals.
Sir, in your idea, sir, parang pwede ba itong marshals ito will be under the sheriff of the judge, kung sakali, parang ganun?
Sa tingin ko, it will be an independent department. It will be headed by a head probably. They will have lawyers. They should be college graduates with background on maintaining peace and order, yung mga graduates ng criminology from the PNPA. Parang ganun ang ilalagay natin. Then may background in investigating cases. Yung talagang marunong.
Okay. We have a limited time already. So can we have the last two questions? O sige, Cecily ko muna.
Kuya Jomar, baka, I'll defer to you.
O sige, last three.
Sir, on the vacancy rate po sa trial courts, yung vacancy rate, sir, sa trial courts, gaano, sir, karami yun, and how does it affect the efficiency of the court?
Yeah. According to the court administrator, mga 20% ang vacancy natin, But I do not know if you are aware of a law that was signed by the president lately, the creation of judges at large. Have you heard about that? Yeah. That should not be judges at large. That should be roving judges. You're appointed as a judge at large. But anyway, the idea is like this. There are some stations in the Philippines where there are no takers, or there are no applicants. If the area is somewhere in Mindanao, you need at least 3 applicants under the Constitution for the JBC to consider. So if there are only two applicants, you cannot fill that up because under the Constitution you have to submit 3 names to the President. Now, the idea is of these judges at large would be like this. Okay, you apply you're appointed as a judge at large, we can appoint you anywhere. So in the meantime that there are no applicants in one judicial station, and that has been vacant for so many years, we can assign the judge at large to handle those cases in that branch where there is no judge yet. So that's the idea. So I think even if we have a 20% vacancy now, we will be solving a part of that problem with the appointment of judges or judges at large. I think we have already Justice Marquez or Court Ad Marquez. In due time, we call him Justice. there is now a move in the Senate and Congress to fund the appointment of at least 100 judges at large in the budget for 2020. If that budget will be included, I mean, if that amount will be included in the budget to fund the appointment or to fund the salaries and expenses for judges at large, next year, I think we will solve the problem of lack of vacancy or the 20% vacancy that we have now.
Hi, Chief. Good morning. This is not to question the wisdom of the magistrates na po, but could you please enlighten us, lay people, for big payouts or perks for a retiring Chief Justice?
What's that big?
Payout or perks for a retiring Chief Justice?
For a retired justice? Hindi ko alam yun kasi hindi pa ako nag-retire eh. No, it's like this kasi. That's under the law, no? That's one way of encouraging lawyers to join us in the judiciary. It is a retirement given to justice provided for by law. But it's not too big. The only, what they misunderstand is that because there is a lump sum of 5 years, malaki yun eh. But that lump sum of 5 years is an advance of your monthly pension for the next 5 years. So, if you retire and you get a lump sum of 5 years, then you will compute what you receive for the next 5 years. So that for the next 5 years, you will no longer receive any monthly pension. But if you outlive the 5 years, then you will continue to receive your monthly pension. Kaya sabi nila sobrang ng laki. Kasi 5 taon yun eh. Unlike other employees in the government, wala naman silang 5-year lump sum. But actually, that might be 5-year lump sum is an advance of the 5-year pension that you are supposed to get for the next 5 years after retirement. Kaya malaki ang kaya sabi nila malaki yan. Probably ang sabi nila marahil pa, well, if you get your monthly pension after 5 years, now if you outlive yung 5 years mo, then you will receive a monthly pension equivalent to the salaries and allowances being received by the incumbent. Sa tingin ko, that's unique to us eh. The other thing is that, I think it's only in the Supreme Court, that when you die, I hope, I'm not saying that they should die, if something happens, because death is inevitable, we cannot say when we will be taken by our Creator. If he is married, as his spouse, then the spouse will receive survivorship. The same amount that a pensioner judge is receiving. Unique sa amin yun eh. Kung if you are like for Judge Banyes, di ba? He died while on duty. The wife will be receiving 10 years lump sum. Kasi namatay eh. But the 10-year lump sum, that is an advance of a 10-year monthly pension. So that if the wife will survive the 10-year period, then she will continue the survivorship amount that she will be receiving after 10 years, tuloy-tuloy pa rin yan. Of course, with the condition that she should not remarry. Kaya unique sa amin yan eh. So those are widowers now, I think, meron nandiligaw sa kanila eh. Thank you for asking that question. Lump sum kasi yung akala nila malaki eh. Okay.
Lawrence Tanoko, Radyo Pilipinas. Ay, sorry.
Oh, hi sir. Sir, concerned lang po ako dun sa sitwasyon po ng mga korte natin sa Mindanao na apektuhan po ng lindol. At ang Public Information Office po ng Supreme Court naglabas na po ng mga initial details po, no? Meron po sa Midsayap na talagang hindi na po magagamit yung courtroom nila.
Muna lang kayo, no? Okay. Court ad, oo.
Opo.
Para naman magsalita.
Sige kay
Sir umaga. Or actually, we continue to receive reports, no? Pero yung sinasabi mo sa Midsayap, we're considering sending yung mga justice on wheels, no? Para gawin nilang temporary courtrooms habang naghahanap tayo ng permanent courtrooms for them.
Oo. Usually, sir, pagka ganyan, may funding din naman po ang Supreme Court para like palitan muli yung kanilang facilities.
Meron naman tayong funding, pero hindi ganun kadali yun kasi maghahanap ka ng bagong building, uupahan mo. No? So, in the meantime, we coordinate with the LGU if they can allow us to use some of their buildings na maaari pang gamitin. And yun nga, yung mga buses natin, papadala natin doon.
Paano po yung epekto nito doon sa mga pending na mga hearings doon, sir?
Ganun yun. Talagang meron pa tayong mga ibang pwedeng gawin kung talagang wala tayong makuhang lugar doon. No? Kung let's say talagang lahat ng mga buildings doon nasira, then we can go to an adjoining municipality or city. Parang yung ginawa natin dati sa Marawi. No? Nung merong Marawi siege, the courts continued to hear Marawi cases in saan nga yun? The adjoining city. So pwede rin yun. So we'll continue to evaluate the situation, and we actually are waiting for the final report of the executive judge.
Yung justice on wheels, sir, maganda yun, ano? Kasi mobile
talagang pinaparedy na natin, talagang padadala na natin yung mga ibang buses. No? Tinitingnan pa natin yung mga ibang lugar na kung saan pwedeng padala yung mga buses natin.
Thank you, sir.
Sir, hello. Lawrence Tan ako, Radyo Pilipinas. Sir, follow up lang doon sa tanong kanina sa perks ng Just and CJ. Sir, are you referring to GSIS lump sum?
No, this is separate. We have our own retirement law. Yung GSI law premium, balik lang sa amin yun. The amount will not come from the GIS. We have a separate retirement benefit amount for judges from the General Appropriations Act.
So dalawa sir yung magiging pension niyo?
Hindi, wala. Supreme Court na.
Supreme Court na.
Personnel, court personnel.
Yung you're confusing it with the employees. Yung employees yun, GSIS yun. Yung judges, there is a separate retirement plan for us, sa mga judges. Sa amin lang yun. Tsaka yung mga biyudo, sa mga biyuda. So, ano na talaga, last two, wala na. So, si Cecil, ako si Benz. One, two.
Sir, status lang sir.
Si Cecil ba?
Yes, sir.
Parang nagugustuhan ako.
Sir, status lang sir, because there's a group of believing inmates, sir. Group of believing inmates, sir. The heinous crime convicts, sir. There's a group of heinous crime convicts who questions, sir, the new IRR of the GCTA law. The new IRR on the expanded GCTA law, particularly, sir, yung hindi sila retroactively dapat mag-enjoy ng benefits of the expanded GCTA law. Sir, update lang, sir, on the status of the case, sir.
There are actually 7 consolidated petitions questioning some of the provisions of the new IRRI. So I cannot probably give an answer to you now because it might prejudge under the rule of sub judice. Those are one of the questions that they raise is your question now, whether or not it should apply retroactively to some and not retroactively to the others. Yeah, I know your question is about retroactive application before the enactment of the law, and no retroactive application to those covered by the law after its enactment. So that's one of the questions that they raise. So let it be resolved first by the court before I could answer your question. Yeah, there's already an order to comment. Yeah, there's already an order to comment. Okay, last.
Sir, this is the most dangerous question that I will be asking you today. But this is a consensus question, sir, from the other people. Background, sir, Chief Justice Narbasa was the last commercial Chief Justice. When while in UST, he played for the Glowing Goldies, it's the predecessor of the Golden Tigers. I remember, sir, Chief Justice Panganiban saying that he used to see Chief Justice Narbasa going around after playing, and he was so proud that it inspired him to take up law. And later on become Chief Justice himself. Ang tanong ko lang, sir, do you have a message for the UST Tigers on Sunday?
Wala naman laban yung UP. may tsamba sila eh. Yun ang delikado. May tsamba eh. Dalawang beses sila talo eh. At saka I think the Athenians are praying that the Roman Tigers will lost eh. Kasi mga tigatin yun, takot sila sa Tigers. Sinabi ni Coach Baldwin eh. Sinabi ni Coach Baldwin during the first game. Sinabi niya eh, na itong UST, dark horse ito. Detecting rin eh. Eh, paano UP Maroons? Sa kulay lang naman yan eh. Sabi ko, ulit. Alam mo, malakas ang tiyamba eh. Sa championship, sabi mo, maglalaban na natin yun at saka UST. Sa dito, lalapasunin lang natin ito. Ngayon, kung maglaban ng UST at saka UP, eh, first half lang, alam na muna, talo ng UP. We try to see you there on Sunday, but I think if I'm going to La Union to attend the Union, the wake of Judge Banyes, but I hope that we can be there. And then, hindi ako nanonood masyado ng basketball eh. Sa TV nanonood ako. Mali ko natalo ng UST, ay pa nanonood. Oo. Eh, mahirap eh. Okay, at siya mo, pero Chief Justice nanalo. Nanood eh. Kaya natalo eh.
Okay, so that concludes our program this morning. So the Chief Justice expects a UST at the New Finance. So again, thank you very much for attending. We hope and we ask the media to continue supporting the Supreme Court and to continue supporting the Peralta Court as we move forward in the next 2 years.
Sorry for waiting for 3 weeks, no, before accepted the interview. Kasi, transition, we have to attend to a lot of courtesy calls. We have to look at, kasi transition, I have to review some concerns of the heads of offices, because the first thing that I did was to meet the heads of offices, and I received a lot of concerns, so I had to attend to them first before I told my friend here, Ryan, that I think it's now right to see them or meet them, because they might think that I'm shying away from you. Actually, I am friendly. You can talk to me anytime you want to talk to me. If your conclusion is that I'm accommodating to you, that's also the same, and even if you have no crowd like this, you can sit in the office and just let me know. Kaya itong si Jonathan Mas Pinsan, maglilig eh. Okay, so thank you very much.